Hello, everyone. I'm hoping that you can actually now see Craig and myself. I think we've clicked all the right buttons for this. Look, today's Craig, you can hear me, can you?
Yes.
Hopefully we're right then. Look, today's about how do we actually, in the collaborative practice or collaborative process, how do you get the most out of your expert? So from my point of view, John Thine, I'm a forensic accountant working with Vincent's Chartered Accountants. I've been working through in the sort of litigation space, doing primarily business valuations through for the last 30 odd years. In about the last 12 years, I've sort of moved in the collaborative space, working as a financial neutral. So that's the space I'm talking about today. I've seen over that time in Australia, the actual process has evolved, and we've sort of adopted the practices that from America and Canada and developed our own, given our culture here. And it's some of those practices we're going to talk about today. So my co-presenter, Craig.
Thanks, John. So I'm Craig Ashford. I'm the Head of Client Development Management for Jones Lang LaSalle Valuation Advisory. I've been a valuer for 20 years, and for the vast majority of that, had a focus on family law valuations. And most recently, I critique and provide guidance and mentoring to our team of valuers around the country. So I had my collaborative training back in about 2011, I think it was, maybe it was 2010. But I have never actually had myself registered as a collaborative expert. However, I'm acutely aware of what is required and help our team deliver that. So on that, we'll move straight into today, so rather than talk too much about ourselves. John, do you want to just change it to the next slide?
I was waiting for you to do that. But that
have I got control of it, have I?
No, you haven't. I've got it.
So as we're all here today, we're here to talk about getting the most out of your collaborative expert and how that engagement differs between the collaborative setting and our litigation or the traditional litigation setting. We'll jump straight into and try and explain that a little bit further. Many of you are probably familiar with this type of statement, what collaborative practice is, but it's the last part of that sentence that really defines the difference between collaborative and that of the traditional litigation process, being a rights-based, not rights-based and not adversarial. So what does that mean for your collaborative framework? We have, I'll just wait for that slide to come through. The collaborative process provides your client choices, and the process gets, well, with that process, it allows you to get the most out of your collaborative expert if you move away from the traditional litigation framework, which is prescriptive and we know is restrictive, both on property experts, financial experts, and also lawyers and clients. So John and I spoke earlier about this, we both find ourselves as experts restricted under the traditional litigation process, which is very sort of regimented in a way that we're instructed. We do research analysis, we provide a report, your client who yourselves ask some questions, and we may end up appearing in court. So to change that, going back to that, we need to adopt a different process. So in this table here, down the left-hand side of the table shows the independent expert under the court.
He's frozen there, so I might actually take over, hoping everyone else can still hear me, and hope he'll click back in shortly. This is actually a slide we put together, which looks at the, I guess from Craig's point of view, where he still actually is the independent expert in both processes, whether it be court appointed or in the collaborative process. In black, we're looking at the expert from a court appointed process. Importantly, paramount duty to the court overrides any duty to the client. We comply with the court expert rules. We've all got our own, okay, he's just dropped out. I'm hopefully he'll rejoin shortly. We all have our own professional regulations we need to comply to. But really importantly, and this is where you can compare it to the collaborative process, our opinion after we do our research is provided in a written format. It's based on usually prescriptive instructions at the outset of the matter. And the outcome that we actually come up with is largely based on those initial instructions. Quite often we don't have the opportunity to have discussions with the instructing parties. And even if we do have correspondence with them, it's usually quite a process to actually change those instructions. So from a collaborative point of view, in the valuation space, if we're working as an expert to the collaborative process, but not one of the parties to that process, one part of the team, we've still got that paramount duty to the court, overrides any duty to the client. We still have the expert rules to follow in the professional regulations. However, this is where it changes quite significantly. We've got the scope is usually determined in consultation, and it's prior to any written instructions or an agreed set of instructions, in that we get the involvement. So in this case here, the property value gets the involvement to actually work out what are the issues that are trying to be resolved. So from that point of view, there's open communication, not only with the clients, but also with the instructing parties, usually together. We're able to explore what is the nature of the value to be determined. And as Craig hopefully will talk about a little bit later, value can mean quite a few different things. There's practical issues considered and the future plans for the property, and verbal delivery, which is really important. That verbal delivery at the conclusion of the matter is actually allows us to sit down and explain and educate as we go. Now, I'm just going to quickly see if I can see where Craig has gone. Oh, he's still trying to get back in. So this is the slide from Craig's point of view when he's actually working in this process. From my point of view, is I'm normally involved in a financial neutral format. So from that point of view, I'm not actually being engaged as a court-appointed expert. I'm actually engaged as a financial neutral. So very similarly to where Craig had a paramount under the expert side, paramount duty to the court, not the clients, complying with the expert rules and regulations. But really importantly, I'm providing a written report. I have really prescriptive instructions, which are usually set at the outset, and there's not a lot of variance from that. Whereas in the collaborative process, I'm actually outside that court process. I've got a duty, importantly, duty to the clients, the parties, not to the court. I still have to comply with professional regulations. Craig's back. Can you hear me, Craig? Craig, can you hear me?
Can you hear me?
Yes, we can. I've just ducked over your slide.
Well, thank you.
So we'll just continue. I'm still in this process, following the same rules and regulations I would, professional competency, they would normally adopt in any case. However, there's a lot more consultation in place. So my information collation and delivery is via meetings, and usually in schedule format, not a written report, which can be quite confusing and long-winded. Really importantly, much like Craig's approach, there's an education focus that we adopt. The instructions aren't necessarily fixed in stone. So we decide on the instructions at the outset, but they're almost fluid in that if an issue actually arises, we can explore that and actually work out where do we go to from that point. We're looking at a party resolution focus. So we're trying to actually take into account what the parties are trying to achieve and moving them towards that result. In addition to our normal instructions, having an independent expert might be, do evaluation of the business, the entities. In this approach, we're quite often putting together the asset pool for the parties. And we're also helping them with that asset pool and the team working as part of that group approach, looking at different pathways to actually divide the asset pool and reality test that asset pool, again, importantly, based on what the actual parties have identified as their interests and goals. So you can see there, the actual financial neutral approach is very different in its whole core to what that independent expert approach is. Craig, just to give you the opportunity, is there anything else you want to say there? I mean, I presented your side very well.
I'm not too sure where I froze and I dropped out there. So if you feel like we've covered that off, I'm happy to just push forward, John, to save time.
Okay. So I just to go into looking a little bit of an example from a financial viewpoint. So again, just to summarize where we were, litigation approach, usually a defined scope at the outset, We go away, we do a collation of information, we interview the relevant principals to actually determine what we need to do to actually value usually the business and the entities. We prepare a written report. We provide that written report, and any questions in relation to that written report are usually in the form of written questions, which you've got 21 days to ask questions and 21 days to reply. At that point, we walk away, unless there's a trial, mediation, something down the track, and we get re-engaged. Under the collaborative approach, a little bit different. So firstly, you want to select a financial neutral that best fits the requirements of that matter. Now, whether that's an accountant, a forensic accountant, a valuer, a financial planner, advisor, is going to depend on what the actual characteristics of that matter are going to be. So if there's a lot of personal financial expense forecasting, it may be a financial planner that actually is more involved. If there's business valuation, it's probably more going to be accountant or forensic accountant, but may also be the requirement for tax structuring, debt considerations, superannuation and the like. So we're looking at how do you actually build the team that best suits the parties we're talking about. We come up with a instruction. The instruction's usually quite often led once they've been engaged by the actual expert coming in, so the financial neutral coming in obviously in conjunction with everyone else is there. So it may be that traditional approach where we're doing the valuation of the business and the entities, but it may be something wider. It may be putting together the asset pool. It may be considering the cash flow requirements of the parties and forecasting. So that scope at the outset is agreed by the team and the parties. At that stage, the neutral will go away and do their collation. They'll start forming their opinions. They'll start then actually having meetings with, usually, but not always, individual, could be combined, individual parties with their solicitors to gain information, but also to educate on what the issues are. What's the valuation mean? What are these values? What are the intricacies and the issues that are coming in there? Once we get past that point, it's usually presenting to the group. And again, you'll see that presentation is in a verbal manner. You'll see the actual work that's been done, and usually that's provided to the parties, but not in a written format. They're not a written report. It may just be Excel spreadsheets that have been printed out. But in that meeting, there's a verbal feedback. So there's an interrogation of what's there and live feedback. So we actually deal with those issues at that point, which then allows us, once everyone's happy, to move forward. Or if there's an issue, we resolve that issue. We then move forward to actually working together to actually come up with different pathways and option generation to divide the pool, look through the various formats, and then actually reality test and come up with the agreement. Really importantly here, that everything's done while considering the interests of the parties that they've identified at the outset, which again is very different to the litigation process. We get a task, we go and do it. So the next one is, this is just an example. So some of you may have actually seen this example before. This one we did a couple of years ago, and it was just a really interesting matter of actually where the collaborative process rolled out. So there's 5 entities that needed to be valued. We had an operating entity, an entity that held the intellectual property, family trust, a corporate beneficiary that receives all the distributions, and a self-managed super fund. So it's sort of a reasonably complex approach, given the actual, what was there was a high level of intellectual property, a high level of goodwill, and there were some real risks in relation to the product that was being manufactured and sold, in that there were only 2 clients and 85% of the actual turnover related to those 2 clients with a whole lot of minors. So there were issues there, and the end result came up with quite a few things to really to consider for the parties' own their own purposes, keeping in mind the interests they had. Now, if this had been done in the litigation format, this was a collaborative process. If been done in the litigation format, we would have had the valuation of the business, which would have involved the consolidation of 4 different entities, the results. We would have had 5 entities being valued. The report would have been 80 odd pages long, and there would have been a really high level of written discussion in relation to valuation methodologies, valuation of intellectual property, and valuation of goodwill. It would have been a reasonably complex report. This wasn't done in that process. It was done in the collaborative process. And in that case, we still do all of the same work that would have been done before. So all of that, so that scheduling you'll see in most accountants' reports That's all still being done. All those methodologies are still being applied and the same level of rigor is being put to it. Just the presentation is very different. So when we actually got to the point where we're presenting to the clients, we did actually go through broadly in schedule format, not on the computer, all the schedules. We brought it back to here. And this is really what the actual parties use to move forward. So all of the valuations of the businesses and entities really fell into this top section here. We also identified that there was a significant Division 7A loans to actually be dealt with, and we worked out what the tax would be if they were to receive a dividend to pay that out. We identified that there was, as part of the restructuring, getting the IP into a separate entity, it hadn't been completed and there were still costs to be incurred over the next year. And one of the issues that came out was, given the really high level of goodwill and the value of the intellectual property, if they were to be sold, there'd be significant tax consequences. So we chose to do this in the format of, let's include all of those costs and let's exclude some of those costs. So we end up coming up with two pools. So we've got all the entity interests at the top, and then we actually valued their other assets and liabilities, coming up with a range of value of $11 to $15 million. So from that point of view, we've got $11, $15 million. One of the big issues we've got is the actual tax consequences. How do we actually deal with that? We've also got a situation where 80 to 85% of the actual value of the pool is resting in the value of the entities. So if just simplistically we look at a 50-50 split, how do we actually affect that based on the assets that are there? And this is where the team really came into the fore. Once we'd presented this, we talked about a few different issues that might be there. The next thing to do was to actually task the actual parties to go away and start thinking about some various pathways that might work for them. So keeping in mind their interests, what are some 3 to 5 different ways of actually splitting the pie that might work for them? In that case, I worked with them individually with their solicitors. And in the case of the husband, he also had his accountant along, which helped significantly. So we got to then, hoping you can see the whole screen. In coming up with 5 different pathways, we look at different options. One of the big options was looking at, could we actually raise any finance? We looked at different ways of actually dealing with the actual tax side of it, and then different ways of actually splitting the other assets and liabilities. We also looked at, in the different pathways, if we could actually look at different levels of debt being risen. The wife in this case staying on board. So these pathways are the wives pathways. The wife staying on board in the business, or the wife actually funding the husband in a deferred payment type scenario. Now, each of those scenarios also had a different level of risk. And you'll see down the bottom that the actual wife pretty much picked the midpoint between 11 and 15 mil, but then actually upped it or downed it depending on the level of risk that's associated with her. So the more debt that's raised, the less risk, the less she's actually going to take. If she stays on board, she's keeping a level of control, so she's happy with that. But if she was funding it, she was basically saying there's higher risk, higher return. So there were just issues in relation to the split that was there that we actually dealt with in different ways. Now, we then went to actually sat down with the husband. Because we were facilitating, we actually had the same 5 scenarios, but just the bottom line was different, and that's where the negotiation started. So that's just a little bit of an insight, very quick, very broad, in relation to different ways of the accountant getting involved in what we've got there. Now, included here, there was a fair bit of high-level tax advice outside my expertise, so we engaged someone to do that. We also looked at looking at the actual, if the wife steps out of the business, how do we actually continue to actually operate the business? So looked at different options there. We looked at the tax side of it, and what actually came out was we actually did a fair bit of budgeting for this process. So just on that one, are there any questions that might be there?
I've got one for you, John. So you talk about risk to the wife and those some of the things that were considered there, but obviously the fund settlement via debt is going to change the risk profile for the husband.
Yeah.
Does that, or where does that get considered?
Craig's a really good question from the point of view that this was actually something that was raised in both of their interests at the outset. So it's a very relevant issue. They, what was important to both of them was to be able to separate their interests, but also they had financial security. And one of the things that this business didn't have previously was a high level of debt, which was going to have a high level of debt afterwards. And on top of that, it was a cash flow lend. So the bank was actually requiring the whole amount to be repaid over 3 years. So the question you raised in this case was really live. How we got round that, the wife recognised the risk and recognised the actual difference in the importance of the interests they both had identified. But we also had to do a fair bit of cash flow budgeting to show the husband where the parameters were. And we also looked at scenario analysis, how much the actual business could downturn before it got into trouble. We also, on top of that, needed to make sure that he had sufficient buffer in the business to, if there was a downturn, he could work his way through it. So we actually put a separate loan facility in place, a debtor finance facility, and we had various assets that were sitting there. There was also a fair bit of additional cash by the end. So at the end of the day, he had about $1.5 million he could still draw upon. But it was one of the big factors that probably took 2 months addressing that issue alone.
No. Okay. Thanks for that. I've lost track of time. So, and
you're good, mate. 10 minutes.
10 minutes. Okay. So let's jump into my side and just to build further on it. That whole scenario concept you brought up just then, John, really, I guess, is pertinent when we're valuing property. So, is market value? A lot of people would say there's only one value for a property, but is that necessarily correct? And I've got a couple of examples that I wanted to share with the group, which I think lead us to the answer that it's not, depending on what the purpose or the use will be that either party are going to have for that property as they move on. So if we look at commercial properties, the first one that comes to mind is the vacant possession versus fully leased value. When you're looking at a fully leased value of a property that is owner occupied, for instance, you are actually, the process in valuation is you actually make an allowance for a letting up period. If the person who is actually using that property for its business chooses to put a lease in it and sell the property, then there isn't actually any cost incurred at all. So the current process that valuations are completed under a litigation model is that if the property is commercial property is run, or should I say the business that they own is run from the commercial property and there is no formal lease in place, the valuers will actually value it on a vacant possession basis. And then to get to the fully leased basis, they would put in let up allowances and so forth. So going back to our slides earlier, where the difference between litigation process and collaborative is, if we're at an outset engaged to understand what the use of the property will be as the parties separate and move forward, we can actually provide a value more representative of what they will be or what that property will be moving forward. Similarly with the residential process, a lot of properties are, I guess, neglected when parties are falling apart, their relationships are falling apart. But when you go to sell a property, most people will actually look to improve it slightly or tart it up, so to speak. And the restrictive nature of the litigation process is that we have to value it as is now. And therefore, again, if the parties that were then to go and re-fence it or do some basic maintenance to improve its appearance and marketability, then the property, and if that was needed to be sold to free up equity, then the value that we've ascribed to it on the as is now value and the value that the parties would be able to achieve it aren't the same. So one of the parties have an inequitable difference. And again, if we were actually advised that if in the instance of what the property would be worth after it's had a few works done, that's the more appropriate value to have reported. The other issue is when you've got an incomplete home and it requires a significant amount of work. If the property is their principal place of residence, then the argument would be that they are undertaking the renovation not for a profit, but for the sole purpose of to reside in it. But yet the litigation approach for valuation would be that we not only work out what the property will be when it's completed, We then deduct the cost of works to get it there, plus an enticement, which is referred to as a profit and risk factor. And it would be arguable that neither party were intending for there to be a profit and risk or profit in the actual process. So again, if engaged in the first instance, both parties would probably agree that the valuation should be, empty of any risk or profit in it. And that goes for subdivisions and so forth too, but there's a lot of other bits and pieces in that space that needs to be considered as to what each party thinks to be reasonable. And it goes back to our point before, is that it is the change in our instructions in the collaborative practice process that enables a valuer to represent a value that is more attributed to what the clients intend for that property. The other thing we've got too is lost my trail of thought with that, but it is all around knowing how your clients are wanting to use the property, and the value being representative of that. I was talking to John the other day about an agricultural valuation we did recently, which was retrospective. And the issue with that was that one party had done a significant amount of works on the property, and was claiming that the improvement to the value of the property should be considered as, I guess, labour for himself. And there's opportunities where if we understand the scope of works, what the argument might be between the two parties at the outset, then we're not bound by that restrictive nature of being an expert to the court. So that summarises some of the real property valuation, objectives in the collaborative process, is that if you engage with us as forming part of those instructions, then your clients will get the best out of us as experts. John,
Craig, no, you're spot on time, but given you gave me a risk question, I'm going to throw a risk question back to you. Often we see property valuations come through, this property is worth X, this property is worth Y, and we're just comparing on price. But clearly there's a difference in the actual risks associated with some of these properties. For instance, if you're looking at residential property, it has a far better liquidity value to a quite a unique commercial property or industrial property. So looking at different risk profiles, whether it be liquidity, whether it be approvals in place, whether it be there are other issues like contamination or potential contamination. How do you deal with that between the two options?
Well, let's touch on liquidity first. I think putting that into the concept or context of what's trying to be achieved here is determine the value of the asset pool. If one or both parties need to raise capital to be able to provide the other their portion of the asset pool, invariably that is one party gets cash, the other gets property, or a bit of split of both. The liquidity obviously becomes quite a concern, because how soon should an asset be sold, or can an asset be sold to provide that that level of funding to the other party? And that, again, that in certain areas in Australia, you can actually sell an industrial property in Brisbane here far quicker than an investment property in a coastal village that nobody ever goes to, for instance. But that information can be provided if we're actually asked to consider that as part of the initial instruction. Approvals and things such as contamination or other impacts that have on property. Again, we are at the, in a space where if we are asked to consider it and provide information for for instance, what a property might be worth in the future, or what property could have a greater potential of future growth or capital gains in the future. Well, there's multitude of different areas of property valuation and property knowledge that can be imparted and educate the clients, sorry, not the clients, the parties to the matter, that would enable you as their solicitors to provide them the advice that they need. So again, the biggest issue and the biggest difference between collaborative practice And the litigation approach for property experts, both John and myself, is about the very first part of our presentation, which talks about our engagement. And then from there, it's about being part of the journey and having open lines of communication with them. And if things change, then we can revise it and move forward. But it's certainly not what's enabled under the litigation process, which therefore we embrace that and encourage you to reach out to us and your property experts or your accounting experts to actually take them on that journey with you to aid your clients. So how do we go for time?
I think we're smack on 1:30 right now. So okay. we're a bit short on, we're finishing up at 1:30, so we're a bit short on question time. But on the screen now, you've got our contact details. If you've got any questions, please shoot us an email or give us a buzz.
Wonderful. Thank you.
Thank you. Cheers.
Cheers.